there's a host of other issues. For example, anti-money laundering. And as we all know, cryptocurrency has a bad rap of being a medium of exchange that can facilitate money laundering and terrorist financing. And so what Canada did in 2014 was it permitted regulations to be created with regard to the phrase dealing in virtual currencies. And to date, we still don't know what dealing in virtual currencies means. So we anticipate the federal government to clarify that term down the road. Until they do clarify that term, what I do is I look at companion legislation in the US, which we can anticipate will, there'll be overlap between US legislation on money laundering and Canadian legislation. So I try to anticipate what I think the term dealing in virtual currencies will mean up here. And so that's what I recommend for any blockchain business. If they need an opinion today on their operations, is you need to get an opinion on with the phrase dealing in virtual currencies with respect to what you're doing. And you also have to consider whether, on the basis of your operations, whether you're technically subject to rules today. And I think a lot of cryptocurrency companies in Canada are, by virtue of being what's called a money services business. I think a lot of them are money services business and they don't even know it. Mm-hmm. So there's a lot that needs to be done, in order to neutralize or plan for the effects of these laws that apply in the money laundering space. You've got to deal with, for example, KYC issues, know your customer. You've got to deal with having a money services business compliance plan in place, etc. And all of this stuff is very important. So that's the anti-money laundering bit of the operational analysis, and it doesn't end there.
Right.
There's also issues of whether or not, in actual fact, you are operating as a bank. And if you're operating as a bank, you could be subject to the Bank Act or potentially the Trust and Loan Companies Act. These are important issues as well. And then there's issues of how are you dealing with your user base? Are you as a company dealing with them in a position of you being a fiduciary? So a fiduciary is where somebody has obligations to someone else because of the relationship. So for example, if I am a cryptocurrency exchange and you are my user and I'm storing all of your private keys to all of your cryptocurrency accounts, am I a fiduciary? So does that mean, do I owe you obligations just by virtue of our relationship of me holding your private keys to your account? That's something that needs to be considered. I think that the answer is probably yes. I don't know that a court has come to the same conclusion, but my sense is that when a court does deal with this issue, fiduciary duties will be a big part of the obligations that blockchain businesses need to consider. And with fiduciary duties come a whole bunch of other duties, sale of goods, consumer protection, general negligence, those sorts of things. So I've shared with you, three major issues in the operational side of things. We've talked about cryptocurrency contracting. We've talked about AML, anti-money laundering, that is. We've talked about the Bank Act and fiduciary duties. We have not talked about tax. We have not talked about token terms of use. We haven't talked about a payment system. We haven't talked about IT contracts, data privacy or insurance. We haven't talked about international law issues. So as you may be able to appreciate at this point, running a cryptocurrency business is actually a very complicated legal process. There's a lot of things that need to be considered.
Mm-hmm.
And that's why I think it's important for every business to get a lawyer in this space to consider all of these issues with respect to their business plan. And if necessary, get lawyers in other jurisdictions where they operate as well and consider their compliance plan in those jurisdictions as well. So in short, if I can condense all of this into one sentence, for any blockchain business, it's this. Blockchain businesses, you need to get a general counsel. And you need to get a general counsel specialized in blockchain and cryptocurrency related legal issues, because that general counsel will need to manage those legal issues as they're considered in a variety of jurisdictions. And that's my best advice to any blockchain business today.
Awesome. That's great. Definitely. Thanks for shedding some light on the subject of regulations and laws as they apply per jurisdiction. This is certainly an issue, say, for even companies maybe that already have raised funds, so to speak, right?
For sure. Absolutely. Yep.
And I'm guessing now it could be potentially an issue, or would it be potentially an issue for any investors who happen to have invested into those actual companies?
Right. That's a great question. So I'll give you the Mt. Gox case as an example.
Great.
So Mt. Gox was a Bitcoin exchange out of Japan that went bankrupt in 2014. And there were class actions started in Canada and in the States by investors who were trying to reclaim, their cryptocurrency from Mt. Gox. The courts here in Canada said, no, we're not touching this. We don't accept jurisdiction because this is a bankruptcy proceeding coming out of Japan. And the courts in the US, as I understand it, said the exact same thing. So why is this important? This is important because if you're an investor in a cryptocurrency business located in a foreign jurisdiction, then you have to appreciate that the rules that apply are largely the rules of the foreign jurisdiction, not only your own jurisdiction. So, if that company goes bankrupt in that foreign jurisdiction, it's likely that their Bankruptcy Act will apply. And if you want to, claim your cryptocurrency as a creditor, you'll probably have to go to that jurisdiction and sue them over there. So these issues need to be appreciated. Blockchain businesses, as I said before, are inherently a cross-jurisdictional venture, for the business. But they're also a cross-jurisdictional venture for users, people who are users / investors by virtue of holding cryptocurrency or token. And so it would be advisable not only for the business to get legal opinions, but also for users to get legal opinions as well with respect to their cryptocurrency investments or their cryptocurrency activities on a foreign exchange. And I think any user, it's particularly important for any user to get a lawyer if they have invested, life-changing amounts of fiat currency in their token activities on a foreign platform. At that point, it's essential to hire a lawyer to figure out if something goes wrong in the future, what are your rights as a Canadian to get back your money from this company in Japan or India or China or the States or wherever. So that's my advice. Both users and blockchain companies should be lawyering up in advance of any of their blockchain related activities.
Right. And now, I guess let's see to talk a little bit about the issue of tax.
Right.
Maybe you could shed some light on that. Let's say if I'm someone who, I perhaps made a fair amount of money, maybe $50 million, okay,
Right.
as a Canadian, in the cryptocurrency and blockchain space, just from solely investing in, these different ICOs, crowd sales, token
Right.
sales, token generation events, whatever you'd like to call them.
Right.
What steps should I take if I'm in that situation when it comes to tax?
That's a great question, and the CRA is still figuring out its position on this issue. Now, there are various bases for being taxed here in Canada. You can be taxed as income. You can be taxed on capital. You can be taxed on inventory in the case of a business, and you can be taxed in the case of a goods or services trade. So you have to deal with I guess, the specific nature of your taxation questions separately. So let me begin first with cryptocurrency treated as a commodity, because we had talked about that before, and I can deal with that fairly quickly. If you're talking about cryptocurrency as a commodity, so that's, cryptocurrency traded between party A and party B, then arguably, because it's a commodity, it's subject to HST. And if it's subject to HST, anybody who's receiving cryptocurrency will need to pay, 13% tax on it, which is contrary to what anybody really expects. And what makes it even more complicated is, depending on the relationship between the user and the platform which facilitates the trade, the platform may have the obligation to charge HST and remit HST to the government, not the user. So this is a very fact-specific inquiry that I would recommend. I would recommend you get an opinion for your particular trades. But that's generally how I look at it. I look at the, whether we've got an HST taxable event, and I look at whether or not the obligation to charge HST and remit HST, whether that obligation is on the user or on the blockchain platform. So that's HST. Let's move on to income. Now, income there's a variety of rules that the CRA has passed down as how to value cryptocurrency in Canadian dollars for the purposes of taxation. So rather than go through each and every one of them, I mean, it can get very laborious to do so. I'll just highlight a couple big ones.
Sure.
So the taxpayer's value when you receive cryptocurrency, for tax purposes, we look at the value received in Canadian dollars. Okay, and that's part of the barter rules. It would be the same thing if you had received, $30,000 worth of cupcakes. You look at the value of what's received, and you consider the value in terms of income in Canadian dollars.
Right.
Alternatively, you have to look at the activities that generated the amount of cryptocurrency that are being declared, right? So do the activities suggest that the cryptocurrency is income, or is it capital, or is it inventory? Like, for example, if you have a business that's mining cryptocurrency, there's a good argument that the cryptocurrency that's created is inventory. It's not income or capital. And if it's inventory, it's treated differently for tax purposes.
I see.
Right. So you can appreciate how complex, all of this can get. Because consider also that if you've got more than $100,000 Canadian in cryptocurrency, it might also qualify as specified foreign property, which itself has special tax treatment rules. So I wish I could give you a simple response as to how cryptocurrency is considered for tax purposes. What I can say is that it's not as if there's no rules at all, and that we're acting here in a vacuum and a complete Wild West with regard to cryptocurrency activities. That's not the case. The existing tax rules are applied to cryptocurrency, or rather they can be applied. The question in my mind is whether CRA will actually proceed with enforcement in certain cases, and whether or not they even know that they should be proceeding with enforcement in certain cases.
Right.
So those are the big issues on the tax side. And like all the others, I would highly recommend that a lawyer be consulted rather than trying to sort of muddle through the crypto tax issues yourself.
Right, right. So I just wanted to quickly revisit what you mentioned about mining, right, and having an actual mining business or operation. You were mentioning that it would be taxable, but considered inventory. Maybe you can happen to shed some more light on exactly how that would look like or happen to work. Say if, one person or a variety of people are running a mining operation, and how they would go about getting taxed in the sense of it being considered inventory.
Okay, so there's various ways. In 2014, the CRA released a public document discussing cryptocurrency being held as inventory. But your question goes beyond just tax consequences of a business in holding crypto as inventory. Your question seems to suggest, or rather your question involves taxation in the hands of employees or perhaps partners of the business. Mm-hmm. And so that creates additional taxation events. So for example, if you are earning the cryptocurrency in the mining operation as income, in that case, the cryptocurrency is going to be taxed in the hands of the employee as income. And the normal the normal rules regarding gifts and benefits would apply. If you are a partner of the business, in that case, different taxation rules will apply because you're not earning employment income in that case. Mm-hmm. I think as a general matter, the principle of specified foreign property would probably apply. I'm not 100% sure. I would need to consider that with respect to the particular facts at issue. But
sure.
Again, you've asked a question that I wish I could answer because it was just so easy. Unfortunately, the question is very involved.